क्या आपने कभी ये सोचा है, ये चारों तरफ जो पावरलूम में साड़ियां बनते हैं, इनको एक दो एक्सेप्शन को छोड़ के कोई क्यों नहीं बोलता कि ये पावरलूम है? इसका दो रीजन है। पहला रीजन तो यह है कि पावरलूम में चीज बनाओ और हैंडलूम बेल के बेचो तो मुनाफा ज्यादा होगा। और दूसरा एक इंटरेस्टिंग रीजन है। करीबन 11 किस्म का प्रोडक्ट, उनमें साड़ी आता है, धोती आता है, लुंगी आता है, गमछा आता है, कुछ एक्सेप्शनल वीव्स जैसा क्रेप, जॉर्जेट वगैरह को छोड़ के ये सब प्रोडक्ट पावरलूम में बनाना इंडिया में एक क्राइम है। इस क्राइम को छुपाने के लिए बहुत सारे लोग किसी प्रोडक्ट को पावरलूम प्रोडक्ट नहीं बोलते हैं। जैसे मान लीजिए कोई जामदानी, सो कॉल्ड मशीन जामदानी बना रहा है पावरलूम में, मशीन बनारसी, मशीन पैठानी, मशीन इक्कत मतलब पटोला, ये सब मशीन में अगर बना रहा है तो उनका अगर ये प्रूव हो गया तो 6 महीने का जेल हो सकता है और जुर्माना भी हो सकता है। जिस एक्ट के बदौलत ये हो सकता है उसका नाम है हैंडलूम रिजर्वेशन ऑफ आर्टिकल्स फॉर प्रोडक्शन एक्ट 1985। तो इस एक्ट के तहत कुछ स्पेसिफिक वेव्स को छोड़ के, जैसे मान लीजिए क्रेप बनता है पावरलूम में मैसूर में, जिसको हम मैसूर सिल्क बोलते हैं, वो यहां पे इंक्लूडेड नहीं है। वो बन सकता है पावरलूम में। लेकिन मान लीजिए अगर कोई टंगाइल बना रहा है, कोई जामदानी बना रहा है, कोई बनारसी बना रहा है, तो उसको तो अगर प्रूव हो गया तो उसको जेल जाना पड़ेगा। ऐसा एक्ट है। तो आज हम जानेंगे उस एक्ट के बारे में, और मेरे मुंह से नहीं, हम जानेंगे एक वकील के मुंह से। तो चलते हैं अगला सेगमेंट में, जहां पे एक वकील साहब ने हम लोगों को एक्सप्लेन किया है कि ये एक्ट में क्या क्या है। चलिए चलते हैं।
Hi everyone. We are enjoying a privilege to get Devrup with us. Devrup is advocate practicing in Calcutta High Court. So today Devrup will explain what is there in Handloom Act 1985. Devrup, thanks for coming. Thanks for your time. Please explain us what is Handloom Act 1985 and what is there? Please explain.
The Act itself is called the Handlooms Reservation of Articles for Production Act 1985. So from the name we get to understand what is the purpose of this act. In simple words, it is for the purpose of preservation of manufacturing of certain article which can be, the central government can under the section 3 can by an order notify. Now, before we go to this, we need to understand what is the reasons of this act coming into force in 1985. There are certain histories to this act coming into force. Before this, there were textile control order which used to be passed under the Essential Commodities Act. Now, there was a difficulty because those textile orders were challenged before the various courts on the ground that this is expressing the act itself, Essential Commodities Act. So, a need was felt that a separate act should be there because handloom industry and powerloom industry, these two things are operating in the same field but in a different way. There are certain disadvantages to the handloom weaver. Now, what are those disadvantages? Technologically, they are in a disadvantageous position than to those having a powerloom or mill sectors. Apart from technological disadvantage, these people are, it was told that handloom is not an individual effect. It is the kind of, it's a family matter. It's a weaver in a rural area, it is the entire family who is involved in the weaving process. But that's not the case in case of power. Now that it was the reasons the government felt that handloom process weaving can generate a large number of employment in the rural areas. And for that, it is necessary that they should be protected, because it was after agriculture, this is the second largest employment generated sector at certain point of time, which is may not be the reality in today's world. So this juncture, this was felt that this act should be brought into force. Now, coming to that, this act was challenged before the Supreme Court itself on a constitutional validity ground, which now in Parvez Akhtar case, now that has been sustained. Supreme Court said this act is perfectly all right. This is a constitutionally valid act. Now, what this act provides for? This act provides for basically that if you go by the texture of the statute itself, there are various sections. Now, Section 3 of this act permits the central government to prescribe, to notify certain articles or class of articles which will be restricted for manufacturing by the handloom. Now, how do central government take that call? That what are the articles? It's not the central government at their whims takes it. That mechanism is also there in the act itself. Section 4 provides for, now there would be an advisory committee. Now, what do advisory committee do? What advisory committee's duty is to look into this aspect, go into this handloom sector. Maybe they don't go themselves, but their action is to look into this aspect, and there are certain things they have to consider. First, if I say is that article or class of article which is being produced by the handloom is for mass consumption. One parameter. The second parameter would be that this is being produced traditionally by the handlooms, either, or third parameters would be that the level of employment which is likely to generate from this handloom industry with that particular class of articles, what level of employment that can generate. And the fourth parameter is that it is for the interest, protection of the interest of the person engaged in that manufacturing of that articles of class of articles and other matters which are relevant. These are the four basic parameters which the advisory committee has to take into consideration before they recommend that these are the articles of class of articles needs to be restricted under this act. Now, if that recommendation is made, now the central government will have the power to issue a notification under Section 3 of that act, saying that these are the articles which now, from today, the date of publication of this notification, become restricted. Now, this order will then be effective. Now, there is an issue. Now, this order has to be placed before the both houses of the parliament. During the session, if the parliament is in session on that session, if not in session on the next immediate session, the parliament now has to take a call whether they are agreeable to the modification or the recommendation made by the advisory committee. They either can go for a modification or they can say, okay, no, we do not agree. Now, if there is a modification prescribed by the parliament, then this act will be applied as modified by the House of Parliaments. And if they do not agree that, no, we don't agree to this recommendation, so it will be scrapped. It will not be used. But that doesn't mean that if in the interim period, if there is any action done, that is protected under this act. Now, what does this act say? This act provides for and one thing is that under the rules, there has to be regular basis. There will be an review. What are the materials which should be incorporated, which should be taken out of this ambit of this act. Now, if government says that these are the class of articles or articles which are prohibited, now no person can except the handlooms, however, cannot manufacture it. If they manufacture it, then there is a penal provision under that. Now, how do you get that that this person is manufacturing which is prohibited under this act? Now, for that, there is a provision that the authorized officer. Now, authorized officer definition is not there. But there is a rules of 1985. There is a definition of authorized officer. Authorized officer is any officer who is otherwise subordinate to the central government, but not below the rank of an assistant director. What are their powers? They can enter into a manufacturing unit, look into that whether they are actually doing anything which is prohibited under the act or not. They can also ask the manufacturer provide me certain information to satisfy themselves whether the manufacturing unit doing anything in contravention of this act or not. Now, if they found that there is a contravention, they have a duty under the rules. They will have to intimate the state government. They will also have to intimate the central government. Apart from that, they will also have to intimate the local police station, jurisdictional police. Because the reason why I say the jurisdictional police, if you look into this, there is, as I said, there is a penal provision. There is a penal provision for violation. For the first violation, 6 months and 5,000 rupees. For continuous violation, there is another further penal interest. Now, this act says that code of criminal procedure will be applicable. The moment the act says the code of criminal procedure will be applicable, it has to be investigated. So it is the duty of that officer, authorized officer, to intimate that there will be there is an error found, and then they can, so that the police can investigate into the matter and take the matter to a logical conclusion. Now, this question perhaps comes to mind that I am a person who is manufacturing certain articles, which is not, as of today, is not a article protected under this. Now, as I said, there is a question of review. During review, central government come to a conclusion that, okay, I am from the tomorrow or from the date of notification, I am protecting it. I am putting it under the schedule so that it does not get manufactured by the Powerloom sector. Do I have to stop it from the immediate day? The answer is no. Because if I was in manufacturing business of these certain particular articles, I don't have to stop it immediately. There is a time frame provided under that. I can continue up to that time frame, and after that I have to discontinue with that. So this act, in overall or in a nutshell, it provides that there will be certain articles which are, in the opinion of the central government, subject to the recommendation of the advisory committee, should be protected for manufacturing being done by the handloom industry. That production of those materials are prohibited in this act, and if found to be violated, there is a penal provision. This is in nutshell the act says.
Okay, Devrup, thank you for your explanation. Let me clear out something for myself and our viewers. That
Okay.
what I got, that there are few articles, there are many, and I'm giving you an example of sari. Okay, and there, so far I read that act that within sari there are few, some weaves are not included, like crepe, georgette, chiffon, etc. Okay, so just imagine me myself is weaving a sari which is included in this act, and that is clearly a criminal offense in India, right? Am I right? Hello, Devrup.
If you say yes, can you hear me? Yes.
Yes,
Yes,
please.
I understand your question. Yes, I understand. So if you say, I got your point that shari, there are certain materials which does not included within that. As you have rightly said, that for like crepe, chiffon, georgette, these are not included under that. If I'm manufacturing those sarees in Powerloom, no offense. But sarees which are prohibited under this act, if I am manufacturing under this and I am not a handloom or weaver, I am committing an offense under this act. That's what it is said. Manufacturing of anything prohibited under this act is punishable offense under this act.
Okay. Devrup, just imagine if there is, as long as you are saying that this is a crime, this is clearly a crime under this act. If if I see an act, just imagine if I see some offenses happening in front of my eyes, I used to report in nearest police station, right? So in this case, where should someone report if someone see that this kind of crime is happening?
To be very honest, in criminal law, there are certain concept. There is certain concept of cognizable offense. There is a concept of cognizable offense and non-cognizable offense. What is a cognizable offense? Police can straight away start an investigation, arrest if that offense is a cognizable offense. Now, this cognizable offense or non-cognizable offense has to be provided under statute. My reading of this act, what I understand is that it is not a nature in the sense of cognizable offense. So police can only be activated provided there is a complaint to the, as I said, information to be given by the authorized officer to the police officer as per the rules for making investigation. So it is only upon an information received from the authorized officer police can get activated. It's not that you like can make an application before the police where the police can initiate an kind of investigation for that. If I understand, if an enthusiast who find that there is a violation, understanding of this law says that he can intimate that concerned authorized officer who should can take it forward.
Okay, okay. And if any case, just imagine if police don't take FIR, then a citizen of India have all the right to appeal to the judicial magistrate so that police may act. Just imagine in this case, authority is not taking cognizance despite of adequate information and report. So where should someone go so that the action can be taken?
Now, what you have just said, like when police do not take an FIR, there is a concept of going, that is 156 clause 3 of the Code of Civil Procedure, to approach the jurisdictional magistrate so that he directs the police to treat that complaint as FIR. But in the present case, as I have already indicated, that individual or normal complaints cannot really be entertained by the police. FIR perhaps might be lodged only at the instance of the authorized officer. Now, if I take an extreme situation, I am a weaver. I found that somebody is violating that. I go and make a complaint to the authorized officer with the hope that the authorized officer perhaps will invoke the provision of this act and then take the matter forward. If we do not do so, if I get your question correctly, then why should that person go? Now, every action of the executive can be scrutinized or can be adjudged by the High Court. So, in those cases, my opinion is that we are handloom industry, a person from an handloom industry or a weaver who says that his business is being violated for contravention of this act, if his complaint is not taken up, he can definitely, in my opinion, move an application under 26 of the Constitution before the jurisdictional High Court for a direction upon the authorized officer, so that he acts under the law. He discharges his duty as prescribed under the law.
Okay, so grossly we got to understand that what is Handloom Act 1985. And thank you, Debru. Thanks for coming. Thanks for your time. And thanks for giving your hard-earned wisdom to explain all these to non-technical person like us. So
it was my pleasure to be here.
Thank you. Thanking you for your presence, and thank you for today.
Thank you.
उम्मीद है आप सब जान पाए कैसे ये एक्ट के बदौलत ज्यादातर पावरलूम साड़ीज, धोतीज, गमछाज ये सब कानूनन जुल्म है, ये क्राइम है इंडिया में। तो आप अगर खरीद रहे हैं बेचने के लिए, आप अगर खरीद रहे हैं पर्सनल कंजम्पशन के लिए, तो असल में आप एक क्राइम को सपोर्ट कर रहे हैं। अगर आप पावरलूम मेड साड़ी खरीद रहे हैं तो तो ये आपका चॉइस है, एक क्राइम को आप सपोर्ट करेंगे या नहीं करेंगे, या दूर रहेंगे क्राइम से, ये आपका चॉइस है। तो आज के लिए इतना तक ही, फिर मिलते हैं अगले एपिसोड में। हाँ, सब्सक्राइब ज़रूर कर दीजिएगा इस चैनल को। बहुत लोग देखते हैं लेकिन सब्सक्राइब नहीं करते हैं। प्लीज़ बेल आइकन दबा लीजिएगा कि नया वीडियो आने से पता चले। और हाँ, प्लीज़ शेयर करें अपने दोस्तों और फैमिली के साथ, क्योंकि ये अवेयरनेस कैंपेन किसी अकेले का काम नहीं हो सकता, आप सबको जुड़ना पड़ेगा। और हाँ, ये एपिसोड कैसे लगा और क्या आपका ओपिनियन है इस बारे में, प्लीज़ कमेंट में ज़रूर लिखिएगा। आज के लिए इतना तक ही, मिलते हैं अगली एपिसोड में। नमस्ते।